Welcome to TCPA Audit. The narrator of this video is not an attorney, and nothing in this video is legal advice. This video only contains the musings and thoughts of a non-lawyer. The purpose of this video is for entertainment and to provoke thought. You should not assume anything you hear in this video is true. The narrator of this video's thoughts and opinions might well be wrong. If you find anything interesting in this video, you should research it yourself. In case you missed it the first time, the narrator of this video is not an attorney, and nothing in this video is legal advice. Please don't ask the narrator of the video for legal advice or to answer legal questions. Only lawyers can give legal advice, and the narrator is not a lawyer and can't comment on your situation. If you would like the narrator to comment on telemarketing-related public information, such as a court opinion, please email tcpaudit@proton.me with a link to the public record, and why you think that public record merits a closer look.
In the past episodes, we covered the adventures of a Ken Johansson and the troubles that he ran into with some judges on how he prosecuted some TCPA claims. But now I want to show some different plaintiffs who prosecuted their case a little bit differently and have gotten a very different reaction from that court. So I'm just going to show this document briefly for the underlying facts of the case. Joseph Barrett received a call to his cell phone. It was registered on the do not call list, and it was someone pitching a national solar program. There's a second plaintiff in the case. He received a call on April 4th and then June 5th. He ignored the first call and answered the second. His number was on the do not call list, and then when he answered it, someone was pitching some products from Vivent, and after he was transferred to another representative, this plaintiff set up an appointment. He paid for something with his credit card, but on the same day, he apparently communicated with someone at Vivent explaining that he'd gotten an illegal call and basically made a do not call request. So this is what I talked about in the Johansson case, where, okay, if he had made contact with, say, Blue Green or even PG&E, and then after made contact he had followed up with a do not call request, his cases may have turned out differently, and these plaintiffs followed that, and you'll see that this case turns out very well for them. And then he got 2 more text messages after his do not call request. The third plaintiff in the case received 1 call from Vivent, essentially, and then apparently this plaintiff had some past history with this company, and he was already on their do not call list. And so that will be shown in more detail later. So these are kind of the facts of the case as recited by the court later. But early in that case, this Vivent moved to dismiss against these 3 plaintiffs, and kind of the underlying argument of Vivent that they're going to make is that these guys just sue too much, and because they sue too much, they shouldn't be allowed to sue us. And as part of their argument, they're going to point out that these guys have too many phone numbers, so they sue too much, they have too many phone numbers. Court, you should dismiss this lawsuit against us, because obviously we get to illegally call people who know how to bring us into court. If you don't know how to bring us into court, then we get to call you, and you're not going to do anything about it. And if you do know how to bring us into court, well, we get to illegally call you, and I can't explain the logic to you because I don't understand their logic. But a lot of telemarketers do have this thought process. So this is a case brought by professional plaintiffs who have made a business of filing claims under the TCPA. Since 2015, Plaintiff Perong has filed over 65 lawsuits, and in the past year, I guess, of them filing this motion, or maybe the lawsuit being filed, has filed at least 20 TCPA complaints in these different federal courts. And they go and recite court cases that have at least his name in it. I don't know if these are all his cases or not. Calls to one of the 17 phone numbers Perong claims to own. So when you scroll down, they claim that Perong is associated with 17 phone numbers through these different lawsuits. I didn't pull, I pulled these briefs, but I didn't pull any of the cases, so they're claiming it's true, and I don't know if this is true or not. I will say that in Perong's response, he doesn't address this at all. So you could say that he tacitly admits that this is true because he doesn't claim it's not true. You could also say that he didn't address it because he didn't think it was relevant. So I don't know why he didn't address it. Those are two possible reasons. And then they go on to complain about this Plaintiff Cunningham. Plaintiff Cunningham is an equally prolific professional TCPA litigant. A search of Pacer shows that Cunningham has filed nearly 150 cases in federal court, the vast majority of which are TCPA cases. Cunningham apparently filed 23 cases from the beginning of 2019 through, I guess, maybe the date that this motion was filed, which was in early November 2019. Cunningham maintains at least 8 phone numbers from which he operates his TCPA litigation business. And they make a lot of claims of TCPA litigation business because, apparently if you get a lot of illegal calls and you know how to collect the damages for those calls, apparently that just puts you in the litigation business. And then apparently once you're in the litigation business, then you can no longer receive damages for illegal calls. And this kind of is like a chicken and egg problem for me. Let's say that the court says, yeah, you're right. They filed enough lawsuits. They're in some sort of business. Now they can no longer collect damages. Now they're out of business. Well, and then let's say they get illegal calls the day after the court says that. Well, now that they're out of business, does that mean they can file a lawsuit for the new claims because, now they're out of business? But then if they do file the lawsuit, does that mean they're in business and they can no longer file for the illegal calls? So this whole line of argument, I don't understand. I get why defendants use it because, what else are these guys really going to argue? They don't really argue that there were no calls. So, a bad argument, I guess, is better than no argument. But I haven't seen this argument really work for anyone. I saw one district court opinion where this line of reasoning persuaded the judge, but then that judge was overturned on appeal. So it seems like kind of a waste of time every time I see this argument made, but defendants really do like it. Let's see, plaintiffs allege receipt of 1 or 2 calls or text messages from Vivent. Okay, well, I guess you shouldn't have made the 1 or 2 calls, but Perong alleges he received an automated telemarketing call from this DSI, which apparently was maybe telemarketing for Vivent, once on April 4th and once on June 5th. Nonetheless, Perong chose to continue the call after being transferred to a Vivent representative. He confirmed the appointment with Vivent, and his credit card was charged for Vivent service. Perong alleges the same day he paid to become a Vivent consumer, he communicated with Vivent, basically asking to be put on their do not call list, and then alleges that he got 2 more follow-up text messages. And then I'm not sure what the relationship is with his call fire. Then they go through about how Cunningham received a single call from Vivent. He'd previously asked to be added to Vivent's do not call list. I don't know the significance of the call fire in this lawsuit. Then back to the claims. The plaintiffs are serial litigants operating a TCPA litigation business, filing over 200 TCPA claims. Hey, judge, pay no attention to what's really going on in this case. Be distracted by irrelevant lawsuits. More claims. If you know how to sue people that give you calls without consent, you must be in a business, and ergo, now you have to accept these calls without consent. Now, Vivent is going to make a very interesting argument here. Am I in the right section? Here we go. So here's Vivent's interesting argument. Vivent's argument is, hey, when you get an unwanted call, you should just hang up, because if you don't hang up, then apparently you want the call, but then if you do hang up, well, then you won't find out who illegally called you. So look, court, they kept us on the phone to find out who we were. So this means that we're not liable for initiating the calls. And so contrast this with Johansson's experience. In Johansson, the judge really took him to task for staying on the line and signing up for services and identifying who the caller was. But these plaintiffs are going to get a very different reception from the court later. I think the different reception from the court was, in part, they took the calls, they identified who the callers were, but then they took steps to very quickly say, hey, I don't want any calls from you. In Cunningham's case, he already had a do not call request on these guys. And then the other thing that I don't see in here, so I think they didn't do it, I don't see these plaintiffs suing for the ensuing calls. It looks like they're only suing for the calls up until they did investigations to find out who these guys were. I know that Perong alleged to have received 2 more text messages, I guess related to installing or using the service. It's not clear to me that he is suing for those text messages. From my reading, it seems not. And the court doesn't seem to be upset with these guys at all in the final opinion. So whenever you get the professional plaintiff, they'll try to work in this Stoops case. So the plaintiffs own some 24 phone numbers between them, and they filed as many as 200 TCPA lawsuits with essentially identical allegations. But the plaintiffs go further than Stoops. Perong's own allegations in dozens of suits he has filed evidence that Perong engages in conduct designed to manufacture TCPA claims. Well, what's their definition of manufacture a TCPA claim? It's Perong describes how, after receiving a phone call from one of the defendants, he scheduled an appointment to have a representative drive to his home and provide him with an estimate. So their definition of manufacturing a lawsuit is investigating to find out who called you. Then in another lawsuit, when the representative and employee of American Renovation Center arrived later that same day, Perong took his business card and told him he was not actually interested in any services. Okay, so to identify the guy, the entity calling, Perong had someone physically visit him, got his business card, and then essentially made a do not call request. So scrolling through, that's kind of that's kind of the same argument that cops make all the time when busting prostitution. Was I pretended to be interested to identify who was doing what and what was going on. And we all know that in court, the judge will totally accept a police officer using deception as part of a legitimate investigation. And the court will have no issue with that at all. And later, you're going to see that the judge apparently has no issue with anything that Perong has done because it doesn't come up in the final opinion, as much as these guys don't like it. And this is a pretty popular telemarketer response is, well, if you did anything, quote unquote deceptive to find our identity, then we get to go free. So, if we break the law by not identifying ourselves and we're successful, we go free. And if you have to do anything to find out who we are, then we also get to go free. So that's a great argument for telemarketers. And if a judge doesn't like you, like the judges didn't like Johansson, they can run with that to some extent if you don't take some defensive measures. Like these plaintiffs. These plaintiffs took the defensive measures of following up with do not call requests. I'm not actually interested in your services. If you call me after I pretend to be interested, I don't sue on those phone calls. So, is it just the difference of the judge between these guys and Johansson? It is a difference in the judge. Maybe this judge doesn't like these guys, but maybe these guys didn't open the door to the judge spanking them because of the way they prosecuted the case. And is that the last that I have noted in their motion? They make other arguments in the motion, but I'm not covering the other arguments. I'm just covering the basic gist of their motion to dismiss, which is these guys have sued too much and they have too many phone numbers. And then what's interesting when we look at the response next is that these guys won't even make an attempt at justifying why they have these phone numbers. And honestly, just in my personal opinion, I say kudos to them. We see in this world where people want you to justify why you have what you have. Why do you have that house? Why do you have a second car? Why did you take a vacation here and then there? Why do you own too many shoes? Why do you own so many guns? And it's nice to see these guys say, I don't have to justify why I have what I have. I don't want you to call me, don't call me.